Hello, everyone, and thank you all so much for joining us today for our Friday weekly webinar. Today, we're going to be talking about cancellation of removal, the 42B, in immigration court. And today, we are joined by our managing attorney, Ruby Powers. She's been licensed since 2008, founded the firm in 2009, and is a board-certified immigration attorney. She is also an author of Build and Manage Your Immigration Law Practice Without Losing Your Mind, and also founded Power Strategy in 2020. So Ruby's always doing something. I'll let her take it away with the learning objectives.
All right, thank you so much. So this topic is because we're seeing a lot. Court has picked up, their hearings are now happening, and we're wanting to talk about this again because court was on hold for about a year and a half here in Houston and sort of intermittently around the country. So 42B is a great opportunity, a form of relief for some individuals who've been here a long time. So we're going to go into more detail. So what is 42B? For a cancellation removal for non-legal permanent resident? Who's eligible, who's not eligible, how to apply, good moral character, criminal bars, as well as understanding the hardship and physical presence requirement, and then just some other things to consider. So what is it? So cancellation removal is an immigration benefit. There's one for legal permanent residents, which we call 42A. And then there's the non-permanent residents, which is called 42B. And each one has their own requirements. We're just talking about 42B today. And if you meet the requirements, there's an application and all of that. If you submit it, and you have to present it in immigration court. If you meet it, then you can gain the legal permanent residency. And so one other benefit is that while it is pending in immigration court, once you have been put in immigration court and notice to appear has been officially filed legally, correctly, I'm trying to think of the right word we use, but basically properly, that's the word I'm trying to think of, properly filed with the immigration court, then you are eligible to apply for the 42B. And thereby, once that you have that receipt of that 42B, you can apply for work authorization. So sometimes this can be a very nice reward, not reward, what would be the word? Well, a benefit, I guess you could say, not reward, sorry about that, benefit for being put in immigration court. So sometimes the only way that a person could be eligible is by being put in immigration court. But you can't just go knock on the door and say, please put me in immigration court. You have to be placed in immigration court to be eligible for this. So it's a more of a, what I would call a defensive form of relief. You have to be put in immigration court to apply. It's not like if you meet the qualifications, you can just go submit the application right now. Now, one other thing to note is if you do win in court, there still is a backlog because a lot of people, they only allow a certain amount of visas per year, per fiscal year. The fiscal year starts October 1st of every year. So this month, it will reopen the visa wait, and so we're hoping that it'll move quickly since there wasn't much court for the last year and a half. So hopefully it'll get rid of much of the backlog, but that is something else to consider. So let's go into who's eligible. So a non-permanent resident may be granted cancellation of removal if they've maintained continuous physical presence in the U.S. for at least 10 years. 10 years. So there are some little details to that, but one of the things to remember is that you have to have been 10 years since you get put in immigration court with the proper filing of a notice to appear, and or a certain type of crime can stop the clock, what we call it, stopping that clock of the 10 years. So for example, if you were here 9 years and then you get put in immigration court, then you wouldn't be eligible for this if it was a properly filed notice to appear. Or if you were here, let's say 5 years and there was a significant crime that stopped the clock, then you wouldn't meet the qualification. So that's something an experienced immigration attorney can help guide you with. Now, they have to have been have good moral character for at least those 10 years. And those will be reviewed on a case-by-case basis. You can have certain crimes, but you cannot have certain larger, more significant ones. And there's a lot of case law to this. It's always changing. Now, you cannot be convicted of a murder at any time or aggravated felony on or after November 29th, 1990, and cannot be convicted of possession of a controlled substance in the United States or any other foreign country unless it was a single offense, so of under 30 grams or less. So convicted or sent to prison and the sentence was 180 days or more. One other interesting fact is that if you, of course, case law is always changing, but last that I checked on this, if you had made a false claim to citizenship, you still were eligible for cancellation or removal. But again, that's not something that you would want to do, but in some cases, this is some people's only form of relief. So who is eligible, falsely testified to obtain benefits under the U.S. immigration, if you are involved in prostitution, convicted or 2 or more gambling offenses, has engaged in human smuggling, habitual drunkard, has not been convicted of an offense that would make him or her removable. So it's listed here as well. So you can demonstrate the removal would result in exceptional, extremely unusual hardship to your immediate family, limited to your spouse, parent, or children who are U.S. citizens or legal permanent residents. And the exceptional, extremely unusual hardship is a very high standard decided on a case-by-case basis. So if you can see here, the way I remember it is 10 years of physical presence, good moral character, and extreme and unusual hardship, exceptional, extremely unusual hardship. So that's the way I look at those 3 prongs. And each one has their own little details. So let's go into each one of those prongs. So what's good moral character? I mean, basically it means like not having criminal history. And if you do, hopefully it's something really small so it doesn't rise to the level of a crime involving moral turpitude. So you want to have you want to be a Boy Scout, you want to be involved in your church, you want to be involved in PTA, PTO, you want to be engaged in those around you and not have any significant crimes. And again, we can always analyze those crimes in case-by-case basis, but those are important to keep to a minimum because there's a lot of discretion in this. There's just a ton of discretion. Gambling offenses, prostitution, perjury, drug offenses on your record may also thwart a finding of moral character. And even not paying child support hurts your good moral character. So all of these things are considered, and case law is constantly changing. So you might be eligible once you come to an attorney and get a consult, and then by the time you finally have court, the crime might be detrimental and not make you eligible. So it's definitely important to have good moral character, not have any criminal record ideally, and if you do, you monitoring what the eligibility, the consequences of that crime. So criminal, criminal bars, the non-LPR cancellation. So what you can is all the applicant was not convicted of any of these offenses in 212A, 237A2, and 237A3. So a conviction is required to be barred from non-PR of removal. Disqualifying convictions include crime involving moral turpitude. There are small offense, the petty offense exception to that. But we'd have to monitor whether or not, if you have more than one, then that's a problem, crime involving moral turpitude. Offenses related to controlled substance. I mean, anything controlled substance usually gets you into danger zone. So you have to be very careful about that, especially as an immigrant. And 2 or more offenses that brought a total sentence imposed of 5 years. Engaging in the business of being a prostitute, aggravated felony, that's definitely a no. Aggravated felony closes so many doors. Firearms offense, high-speed flight from an immigration checkpoint, etc. So there are some, like I said, case law can change on a regular basis, so we have to analyze things at that time. So let's move over to the prong about the exceptional, extremely unusual hardship. So this is a higher standard than when we've talked about waivers in the past, though it's extreme hardship. So extreme hardship is, like, let's say 1 standard, and exceptionally, extremely unusual hardship is higher than that. So this is where it can be very difficult because I think this is where it really gets people if they don't have that higher of a standard. It's often the most difficult requirement. The applicant must show the deportation will cause exceptional, extremely unusual hardship to the qualifying relative or relatives. So who is a qualifying relative? So it's a U.S. citizen or legal permanent resident, children, spouse, or parents. So it has to be the hardship to one of them. The hardship to the applicant does not technically count. Because if your client does not have a qualifying relative, then they're not eligible. And the law is very specific as to who constitute a child's spouse and parent. And so they're very specific in the INA about that. The other thing they look to is the age of the children as well. So there's lots of different considerations. When you're trying to prove this element, you're usually talking about like if they have any health concerns, financial, psychological, educational, did I say financial? I mean, just like the normal spectrum that you would show for hardship, it would be, you take it up a notch or two. So, if you're taking care of your elderly U.S. citizen father and they know all their medications, one of your children has certain learning disabilities, and you're the one who's active and engaged in with their school and teaching and helping guide your child, or you just basically we just analyze your whole life, figure out what we can talk about in terms of hardship, and showing that proof is so critical. It can be very discretionary as to what a judge considers meeting the standard. So the more we have of potential hardship and proof, the better. And generally, totality of circumstances is how we would weigh everything. And so if you have a little bit here, and then a lot over here, you add it all up, and then that's how we're trying to meet that exceptional, extremely unusual hardship. So this is, like in the slide says, can be one of the hardest ones to prove. And again, it has to be to a qualifying relative. Now, physical presence. Now, sometimes people take this one there for granted, but really, sometimes people are living off the grid and don't have a lot of proof of them being here because they are not working legally, and maybe they don't have a social, very likely, and they don't have credit, and they might not have a bank account or what have you. So then sometimes it lends itself to not having a lot of proof. But the best way, what judges usually love, is to see 10 years of taxes. Now, some people don't do taxes because they didn't get the tax ID number and they didn't have a social, but if you don't need a social to do taxes, you can do it with a tax ID, and you don't need status to do a tax ID number here in the United States. So the best way to prove this is taxes. And if not that, then bills, hospital records, civil documents, rent, home ownership records, school transcripts. I mean, basically any paper trail that you can prove, bank statements, bills of water, electricity, sewer, insurance, health, life, car, pretty much as you possibly can. And for some stay-at-home parents who don't have a lot of proof and they didn't work outside the home, we've shown records that they were the point of contact at the school, or they were engaged in their children's education, and birth records, marriage records, divorce records, hospital records. So you really have to be creative, and this is really where you need to have a significant amount of proof for every year to prove the 10 years of physical presence. So when we're putting the application together, like most things, it's the application. You make sure you're meeting the burden of proof standard. Again, so that's the extreme and unusual, exceptional, extremely unusual hardship. And then you put all the supporting documents. So if let's talk about the physical presence. You'd show those 10 years. If you talk about the hardship, you show all those proof, like psychological, financial, mental, health, for that proof of the hardship. And then for the good moral character, letters from friends and family, maybe a letter from the minister, the rabbi, showing proof that you are engaged and have good moral character in the absence of a criminal record, ideally a police clearance record. There's nothing to show for it. So You will have to do biometrics at some point, and after the application's filed, and we have to put up biographical information, where have you lived and worked, any problems with the law, anything that's not in English has to be translated and certified, and then photographs, as well as the filing fee this is what you normally would need to submit. But when a person is put in immigration court, we will generally file this as soon as possible, so they'll be eligible for work authorization as soon as they get the receipt for the 42B, and then we can always supplement the record when we get closer to the merits hearing of anything that's happened from the filing of this application into the merits. So one thing I wanted to mention that we've been seeing recently from this summer, there was a memo about the OPA being able, or the trial attorneys being able to stipulate to grants or continuances or admin closure and all of these things. But one thing that could be that we're starting to see is that you could request to stipulate to a grant, which means like approval based on the record, what was already submitted. And so this is something to consider that could could help eliminate the uncertainty, as well as putting everyone on the stand and being able to just, if you have a strong case and we could request the prosecutorial discretion stipulation to a grant, then it is possible for that to happen. And we're starting to hear about this and request this. And so this is relatively new, but this is something exciting. So if you have had a case where you were put in immigration court, maybe you didn't file for anything because you were looking for an attorney, or maybe you had an attorney, but then either they're not continuing in court, or you're just want to get a second opinion, or you just haven't found somebody yet, or maybe you submitted just the basics and you still need to find an attorney. So we can help you with your immigration court case, regardless of where you're located. We're in Houston, but we can help you wherever you are in the United States. And this is just a great form of relief. You just need to make sure that you meet the requirements. Again, the top 3 are 10 years of physical presence, 3 exceptional and extremely unusual hardship, and 3 good moral character. And so that hardship, again, has to be to a U.S. citizen or legal permanent resident, spouse, parent, or child. So that's 42B in a nutshell, Dana. I hope we did a good job there. But we've got a lot of experience and we can help you. And I would just say, like I'd say for anything, especially for court, don't wait till the last minute to find someone to help you, because if you want the optimal success, you want to make sure that the attorney has the time to review your record, collect the documents with you, prepare the best case, put it forward, possibly ask for prosecutorial discretion for a grant, or stipulate to certain elements of those prongs that we talked about. So don't delay. Make sure you find an experienced immigration attorney and try to do the best at preparing your best case. So how can people stay in touch with us and going forward?
So there's this handy dandy QR code here on the screen. You guys can go ahead and scan it. And in there, you can see all of our previous Facebook videos and all of our upcoming events. Again, if you've missed any of our past presentations, you can find those on our YouTube as well. And we're always open to new ideas. So if there's anything that y'all would like to hear about, please do let us know. Y'all can leave a comment down below on our Facebook post, or shoot us an email at contact@rubypowerslaw.com. And I would also suggest following us on our social media. We post regularly on policy updates and immigration trends that are going on in the news. And our very own attorney, Ruby Powers, is always featured in the media. So stay tuned for some of her appearances. But that'll be it for now. We will be sending out the webinar schedule for November shortly, and then you can find and register for those on our blog. But thank you all again. You all have